I'm Hans von Spakovsky. I'm a senior legal fellow at the Heritage Foundation. I was asked to take a look at Art's paper, which is a very good paper on the problems inside the immigration court. So I'm going to talk about that a little bit and then talk a little bit about a couple of other recommendations that I have on this issue. But we need to understand the numbers. Now, Art's done a very good job of going through the huge backlog of cases in the immigration courts, how they increased significantly during the Obama administration, how not only did the backlog of cases increase, but most significantly, the time needed to complete cases went up in a huge amount. Now, it's important for all of you and for those watching this on C-SPAN to understand that the immigration courts are not Article III federal courts. They are administrative courts within the U.S. Department of Justice. We have similar courts in other executive agencies, people who, for example, get into disputes over Social Security disability benefits know that they end up before an administrative judge in the Social Security Administration. So we have two levels within the Department of Justice. We have the immigration judges who act as trial-level judges and hear cases, and then we have the Board of Immigration Appeals that Judge Burman has mentioned, the BIA. So you have two levels of courts. And it's important for everyone to understand that aliens have very extensive due process rights in those courts. I think the last time I looked at the manual describing the procedures for the immigration courts, it was over 200 pages. And not only do they have all the kinds of rights that we would expect that U.S. citizens have in courts, everything from the ability to be represented by counsel, they have the right to see the evidence against them, et cetera, et cetera. I mean, there's a whole extensive set of due process rights, and that's important for people to understand. These are not kangaroo courts at all. Aliens have extensive due process rights, and that's important for everyone to understand. Now, Art's gone through and defined the problem in his paper, and he's come up with a recommended set of solutions, all of which I agree with. More resources are certainly needed. More judges, more staff. The Attorney General has already taken good steps towards that. It's not just that they need new staff, but something else the Attorney General said is also important, which is to speed up the process of approving individuals who are going to be judges. Speed is very important in this process. Now, one of the points Art makes in his paper, which is very important, is the change in border policy and its effect. Because the whole point of having an administration who makes it very public that they are actually going to enforce immigration laws, which prior administration made clear they were not going to do, is that has a deterrent effect. Anyone who doubts that can look at the numbers. The number of people trying to cross illegally across the border since the Trump administration started has dropped dramatically. I think the last time I saw the numbers was like 60%, over 60% down. That is important because the less people you have trying to get into the country illegally, the long-term effect on that is to reduce the number of cases in the courts. Now, one of the other problems we haven't talked about today, but is an important one, is that we also have had the significant problem of unenforced removal orders. Once this process has been completed, and there's actually, a final decision by an IJ, an immigration judge, and the Board of Immigration Appeals, and a removal order is issued, those go over to the Department of Homeland Security for enforcement. And as of May 2017, the number of unenforced removal orders was 953,000. A huge number. Why? Well, because the prior administration didn't really want to enforce these removal orders, and so they let them pile up at DHS, and that's something that this administration has got to do something about. But the deterrent effect is very important. Another number that I found was that from 2009 to 2013, so basically during the Obama administration, 95% of aliens deported were criminal aliens. So in essence, people knew that if you got into the country illegally, unless you broke another law, you were not going to be removed by the administration. And the change in policy from this administration, as Art says in his paper, the change in interior enforcement of saying that if you're in the country illegally, you are not given immunity, that's important, again, to reducing the backlog in the courts. By the way, the prior administration wasn't even very good at doing that. You know, it said its priority was removing criminal aliens. The last numbers I saw were that large numbers of what ICE considers level 1 and level 2 offenders. ICE has this categorization system for, depending on how serious the crimes are that you have committed. And I'm not talking about immigration crimes. I'm talking about other crimes committed when people are illegally in the country. Level 1, level 2 are the worst offenders. Those are murderers, drug traffickers, kidnappers, sex offenders. Well, in 2013, ICE released 36,000 convicted criminal aliens. In 2014, they released over 30,000 convicted criminal aliens, people who had been convicted of serious crimes. Since 2013, according to another study CIS did, there's at least 124 criminal aliens implicated in 135 killings after ICE refused to remove them. One of the other problems that they talk about is the continual and constant continuances given in these cases. Now, here's the point that needs to be made. All of these changes that help deter illegal aliens from coming into the country and staying in the country are going to help the situation in the courts. But the other point that needs to be made is that illegal aliens, and I'm going to use that term because that's the correct legal term, that's the term used by the courts, particularly the U.S. Supreme Court, they should not be given more rights than U.S. citizens. And there are a number of examples of that, including in the immigration courts, that need to be changed. For example, as Judge Burman said, federal immigration law actually gives immigration judges the ability to impose civil sanctions, to enforce their court orders, to impose sanctions on attorneys, for example, who might file a frivolous claim, et cetera. But that ability is dependent on the Attorney General of the United States issuing regulations outlining how those powers are to be enforced. Unfortunately, no Attorney General has ever issued those regulations, and it's impossible for us to have an orderly court system unless the immigration judges are given the ability to do that the same way federal judges have the ability to do that when people, U.S. citizens like me, for example, appear in a federal court. And that's something that needs to be fixed and done immediately. Another problem, and this is something that, again, shows that aliens should not be given more rights and better conditions than U.S. citizens. If I file a lawsuit, a civil lawsuit against the federal government in a federal trial court, an Article III court, and I lose, I, of course, have the right to appeal the case to the Court of Appeals for whatever circuit I'm in. Aliens certainly have the same right. If they lose their removal case before an immigration judge, they have the ability to appeal that case to the Board of Immigration Appeals. But as a U.S. citizen, I have to pay the costs of my appeal. I have to pay the filing fee in the Court of Appeals. I have to pay for the cost of the records that are going to be sent from the trial court up to the Court of Appeals. I have to pay for the cost of the transcript, if that's necessary, going up to the Court of Appeals. However, as an immigration judge testified before a House Judiciary Committee meeting, this was former Judge Michael Heilman, he said, you know, why are there so many appeals? How many appeals are there? Hang on one second, I have that number here. Almost all of the cases that are heard at the IJ level overwhelmingly are appealed. That is not the way it works in the federal courts. And you would sit there and go, why is it 99% of cases from the trial level are appealed to the BIA. Well, that's because there's no cost to the illegal aliens. The filing fee is very low to file an appeal. It's $110 according to Judge Hallman's testimony before the House Judiciary Committee. However, in the majority of cases, that fee is waived by the Justice Department and the BIA. Second, the alien isn't charged for copies of the records or for copy of the transcripts. All of these costs are paid for by the Department of Justice, and that means American taxpayers. So American taxpayers are subsidizing the appeals costs of all of these cases, something that does not happen if an ordinary U.S. citizen is involved in a federal lawsuit against the federal government and has to appeal his case. So there is absolutely nothing to stop the filing of frivolous and meritless cases. And in fact, Judge Hallman's testimony before the House Judiciary Committee was that the vast majority of these cases were frivolous appeals filed with the intention of simply delaying the removal of this particular alien. And that's something that needs to be fixed. Those costs should not be waived. The rules for that should be the exact same as in the federal court system. That's the fair thing to do, and that's something that needs to be changed. The other thing that is not mentioned that I think needs to be done is this. The U.S. the U.S. Supreme Court has said in numerous cases that, and I'll start with one called U.S. ex rel. Knopf versus Shaughnessy. It's a 1950 case, and it was a case involving the right of an alien to enter the country. And here's what the Supreme Court said, quote, "Whatever the rule may be concerning deportation of persons who have gained entry in the United States, it is not within the province of any court, unless expressly authorized by law, to review the determination of the political branch of the government to exclude a given alien." More importantly, the court emphasized this, that the due process rights of any such aliens are limited to, quote, "the procedure authorized by Congress." What does that mean? It means that illegal aliens do not have constitutional rights. And the only due process rights they have are those that Congress gives to them in immigration law. And 100% of the authority for determining our immigration laws is given to Congress. In a second case from 1953 called Shaughnessy versus Mesel, the court made it clear that when it was talking about traditional standards of due process, which they said do have to be given to an illegal alien who's the government is attempting to deport, that only requires a hearing before an executive or administrative tribunal. In other words, they do not have to be given the right to go to court. They do have to be given the right to appear before an administrative tribunal, which is the system that we have of immigration judges and a board of immigration appeals. Now, Congress in immigration law some years ago limited the appeal rights of illegal aliens once they have completed the two-step process at the Department of Justice to only going to U.S. courts of appeals. They can't appeal to the federal district courts, which is usually what you would expect to have happen. They can only appeal to the courts of appeal. There's no reason for them to have that right. That is flooding the federal courts with meritless cases. The last numbers I pulled from the U.S. The Administrative Office of U.S. Courts is that over 80% of the appeals in the federal Court of Appeals system that are administrative agency appeals, in other words, appeals of decisions made by federal agencies, are these immigration cases. And the vast majority of them are also frivolous, meritless cases. But there are enough of them there that, as Art points out in his paper, in his discussion this morning, you have federal judges interfering with the decisions of the executive branch on aliens, which is absolute, as the Supreme Court has basically said. In that Supreme Court case from 1953, the U.S. Supreme Court said that the due process that these aliens are entitled to requires only, quote, an opportunity at some time to be heard before such officers that are given the authority to act on the alien's claim. So I think one thing that ought to be done is, at the very least, what Judge Burman has said needs to happen, which is these appeals need to be taken away from all the federal courts of appeals and put into one federal court that only deals with immigration appeals, similar to the Court of Federal Claims. You know, there's already a precedent for this. I actually would take away completely the right to appeal to the federal courts, allow this to stay within the IJ system, the Bureau of Board of Immigration Appeals. The due process rights there are extensive, and frankly, the federal courts do not need to be flooded with these decisions. And I think that's actually the final change that needs to be made.